Well, good morning, everyone. My name is Dr. Michelle Lim from the Centre of Environmental Law at Macquarie University, and we're delighted today to be hosting this colloquium with the New Zealand Centre for Environmental Law at the University of Auckland. And the lands that Macquarie University is on are the unceded sovereign lands of the Wadamadugal clan of the Darug Nation. And we are proud, and I'm very honored today that Dr. Joan Ray, a community Darug member, and also our keynote for the keynote session tonight, has so generously offered to do the welcome to country this morning. Thank you, Jo.
Thank you very much, Julie. So my name's Joan Ray and I'm a Darug community member. I will start this welcome in language and then transfer to English after that. So, Bayawu, Budjuri, Darug Yurayin, Nyaya Yurubarang, Ji, Darug, Wallamadigal, Yurayin, Bayawu Gulbanga, Gananigang, Yura, Guragal, Yagu, Gurabagu, Darug Yura, Bayawu Niyini, Yanama, Budjuri, Gumadagu, Darug Nurawa, Nubadigu, Didrigura. Warramai, Midiga. Welcome everyone. My name is Joan Ray and I'm a Darug Aboriginal community member. Welcome into Darug Nura country, the place of belonging for Darug speaking peoples. Darug Nura covers the majority of the Sydney Basin. I pay my respects to our elders, past, present and emerging, remembering they always have been and always will be caring for country. I also acknowledge and pay my respects to the elders that are present today and those you represent in your respective communities and countries. My ancestral connections are through Wallamada, the place whose people are ancestrally and spiritually connected to and responsible for the Wallamai, the black snapper fish. While I live across the river now on Gamarai or Narungra, I was raised and educated through Wallamada. My primary school under the Port Jackson Figs, playing under the influence of the Durrumbara, or what we call the Lane Cove River now, her mangroves, oysters, and the wind whispering through the Casuarinas. These are primal, foundational childhood memories for me. And fishing on the weekend was an event, of course. I have lived more than 60 years within Darug Nura, conscious she is my place of belonging across that time. I have watched how human beings have destroyed and toxified her lands, poisoned her rivers, polluted her air. With a human population of more than 5 million in Sydney now, Darug Nura and our neighbours' country suffers. As this environmental colloquium, law colloquium, is centred in caring for country, with a clear consciousness of the threats that all countries now face because of the impacts of human-induced climate change, consideration of the relationships that cause these threats, the impacts and failures of Western law to sustain and nurture the well-being of Nura, on which we depend, must underpin the discussions and considerations of this event. The place of developers, government bureaucracies, and concepts of what is sustainable practice cannot be ignored. As future and current environmental lawyers, you have important ethical considerations and roles underpinning your work with all your local presences, places, and peoples. As you undertake your rulemaking, remember that all our ancestors and all our continuity is interwoven with Nura's well-being. When Nura is destroyed in any part, we are destroyed in part as well. When millions of fish are gasping for clean, oxygenated water, it is a reflection of what we may one day face. In fact, just in today's news, on the Parramatta River, which is a boundary of Wallamada, there's a toxic fish kill happening as we speak. So When millions of fish are gasping for clean oxygenated water, it's a reflection of what we may one day face. When our landscapes are scarred through enormous mining excavations, remember we too can be scarred and brutally damaged. As life is destroyed, we are destroyed. Today, as I welcome you into Nura, I do so trusting that you will engage thoughtfully and respectfully with the ancestors, human and others. Engaging consciously through Nura, remember that you are co-becoming through Nura. She is influencing you, just as you are influencing her and affecting her. Together we transform, and I ask that you remember with deep gratitude and respect your relationship with her. After all, our very lives depend upon our caring for country. Yanama Budri Gumada, walking with good spirit. Welcome, Morami, Didgerigura, thank you.
Didgerigura and Joe, that is just such a wonderful way in which, particularly in this virtual context, having that connection to Nura, but also what our responsibilities are, not only on Wallamada land, but far beyond. And it's been wonderful to be able to bring into this a range of people from so many different lands, and I'm very excited for the conference and so excited for your presentation. I've had the privilege of having a sneaky peek at your slides, and I'm sure we'll all really engage with the conversation this evening. Before I hand over to Paul and the exciting first session we have today, I'd like to very quickly introduce you to the people whose names you've been hearing through emails who have brought this conference together. Paul Govind, of course, who has led the organization of this conference. Those of you who know his scholarship will see it resonating through the conference program. Paul is also the Deputy Director of the Center of Environmental Law at Macquarie University. Also, Ningye Liu, who is the Director of the Center of Environmental Law, for his experience and guidance in organizing this colloquium has been very much appreciated. And we are very excited to have Professor Caroline Foster from the New Zealand Centre of Environmental Law, the University of Auckland, being part of the organizing committee. Not only is she so smart and so hardworking, but so nice as well. And thank you, Caroline, for your beautiful, encouraging emails all throughout. And thank you for your mahi. And also there's two other people who you've probably heard a lot from this conference. Thank you to Sarah Vanderfield, who's been helping and already in the chat box here, welcoming everyone and helping with all of the tech issues. Nishala McDonald, who is the person who's running the Center of Environmental Law Twitter account. And don't forget, hashtag 8th Frontiers Colloquium, Frontiers Environmental Colloquium, and you can follow Cell at Macquarie Cell. Two other people I'd like to thank, the Kylie Perry and Fiona Tan from the events team, Macquarie University events team, and also Leanne Hunter, their director. And thank you too to Tamme Kulkarni, who will be assisting with the tech on Friday afternoon. And so it is with much pleasure that I will hand over to Paul Warami, and also Tena Kotu, Tena Kotu, Tena Kotu Katua. Thank you.
Thanks, Michelle. Just quickly, I think Michelle herself has sort of, as she always does, sort of maybe excluded herself from that very generous series of praise and acknowledgement. Michelle really drove this forward in the last couple of weeks while I was away from the university. So my personal and our collective thanks to Michelle, especially for moving the conference from, I think, sort of conception through to reality, I think is one way of putting it. Again, thank you to Dr. Joan Ray for that amazing welcome to country. this is a hugely important part of what this colloquium represents, as Joe pointed out. We're here to speak over the next few days about responsibility, the ethic of responsibility, as I sort of like to call it. But responsibility for most of us here as lawyers who have been trained, most of us, I emphasize not all, most of us who have been trained and have practiced and have researched, etc., within a Western legal system, this idea of responsibility seems quite novel to us in terms of how we conceive and how we apply environmental law, particularly in this epoch of Anthropocene. But for Joe and others, responsibility has been something which has been a fundamental and cherished part of culture and law for thousands and thousands of years. And I think this is very important to acknowledge from the outset of this colloquium, is that whilst we talk about responsibility as something new, it's only new to particular eyes, if you like to put it that way, particular types of legal systems and cultures. And there's so much that I think Western law, the Western legal model, Western culture needs to learn, needs to acknowledge before we sort of move forward, and particularly that these ideas are not necessarily new. They're only new to perhaps to us. So on that note then, I'd like to move forward and introduce the first panel for the 8th Frontiers Colloquium in Environmental Law. We're just waiting for, I think, one more group to log in, but I think I can move forward at this stage and perhaps do some introductions. The first session is entitled Reconceptualizing Rights for the Benefit of Nature. And I think this is such an important aspect to start on with regards to some of our legal discussions. When we talk about responsibility, the ethic of responsibility, we can't really escape, I think, the discussion of rights. Responsibility and rights share an interesting and sometimes difficult relationship that I think we'll see unpacked across the next couple of days. But we're going to start with this discussion and analysis, I suppose, of how rights, the idea of rights, the concept of rights, can be reconceptualized to benefit nature. So something which is very much, historically at least, an idea which has benefited humanity in the Western legal tradition, how this now can be transmitted to nature. So we've got some excellent speakers today with, I think, some really exciting topics. So I'll just quickly go through the names here. Justin Sobion, Jolene Holtz, Anna Flavia Coletto, and Gabriel Fagunez. So two of the papers will be on behalf of other authors who won't be joining us, but of course their names are attached in the program and the abstracts. So the first speaker we'll be hearing from this morning is Justin Sobion. Justin was called to the bar in Trinidad and Tobago in 2002 and the Commonwealth of Dominica in 2008. He served as a judge's research assistant at the Supreme Court of Trinidad and Tobago in private practice, and later at the Ministry of Foreign Affairs, where he was posted as the first secretary to his country's United Nations mission in Geneva. He also served as an advisor in the Office of the President of the UN Human Rights Council. Justin holds a master's degree in international law and environmental law. He's currently a PhD candidate at the University of Auckland, of course, one of our partners here today, where the focus of his research is Earth trusteeship and the rights of nature. Justin is the coordinator of the Earth Trusteeship Working Group. He's also coordinating Caribbean support for Vanuatu's climate campaign at the International Court of Justice in The Hague. So I'll pass over to Justin, and just one note to Justin and all the other speakers. I'll give you some very subtle hints when you're about 10 minutes into your paper. So you have about 5 minutes remaining. Okay, so over to you, Justin.
Thank you, Paul, for that introduction, and thank you, of course, to the universities and organizations who are responsible. I mean, it's a New Zealand, Australia mainly connection. Thank you for this timely colloquium. If I may just share the screen because I'm conscious of time. Yeah. All right. So I would like to talk about Earth Trusteeship and its future contribution to environmental law and planetary governance. So we have, which I will start with, persons will of course want to know what exactly is Earth Trusteeship. So Earth Trusteeship initiative was launched on the 10th of December, 2018 at the Peace Palace, The Hague, by Global Civil Society. The timing of the launch was intentional because it represented this 70th anniversary or the commemoration of the Universal Declaration of Human Rights, which was adopted in 1948 and was, of course, when adopted, it was a direct response to World War II. The environment was not at that particular time a major concern for various delegations and persons across the world. And this document, the Universal Declaration of Human Rights, was of course human rights based, which had of course political, civil, social, economic rights. It was not until the birth of the environment movement in the 1960s that the environment and the earth, the care of the earth, started to have some traction. And that eventually led to the Stockholm Declaration, 1972, which which I should mention, we are now celebrating 50 years of this first UN environmental conference, Stockholm plus 50. So the adoption of the led to the Hague Principles, which was adopted the same day as the Trusteeship Initiative, which speaks about, the Hague Principles speaks about, which is of course a soft law document, responsibilities to the earth, principle 1, principle 2, responsibilities within the community of life, and responsibilities for human rights, which is principle 3. For the intentions, all purpose and intentions, we will let's focus mainly on principle 1 and 2, which are more ecocentric. And the Hague Principles, of course, not only focuses on rights, but also responsibilities. What are our responsibilities to the earth? What our responsibilities are to the community of life? So it goes a bit further than Universal Declaration of Human Rights 70 years ago. You can see, of course, more of these principles in detail if you visit Earth Trusteeship, www.trusteeship.world, if you want to get into a bit more detail. That being said, I'll define Earth Trusteeship. It's a relatively new concept. As I said, it was just over 3 years old by the Hague Principles. Earth Trusteeship is the institutionalization of the duty to protect the integrity of Earth's ecological systems. This is a definition given by Professor Klaus Bosselman at the University of Auckland. And Earth Trusteeship is also described as a powerful realization of altruism, where you think about not yourself, own self-interest, but of course the community of life and the Earth community and future generations, waiting to be adopted as an overarching principle of governance in international environmental law. That is Hans van Willenswaard from the Netherlands, now based in Thailand. And these two persons were integral in shaping the adoption and the drafting of the Hague Principles. It's an ethical concept common to all cultures, indigenous cultures especially, and it's a common obligation of states that is already expressed in international agreements. For example, a Paris Agreement recognizes in the preamble the importance of ensuring the integrity of all ecosystems. So we just touched into the core principles. Humans are an integral part of nature. Principle 1.1. Again, nothing is new. We're not reinventing the wheel here in the Hague Principles because it's seen as in the World Charter of the Nature, the Earth Charter, the Universal Declaration of Rights of Mother Earth in 2010, which was adopted in Bolivia. This was during the World People's Conference. And principle 1.2 basically articulates that states share responsibilities for nature in alliance with their citizens as equal trustees of the earth and the integrity of Earth's ecological systems. This, in essence, in the Hague Principle, is a core principle of Earth trusteeship. And this encapsulates it, Principle 1.2. And we see humans, going back to Humboldt, for example, he said humans are an integral part of nature. He said that nature is a reflection of the whole. So we are looking at everything in working together in sync, not just human beings. Principle 2.2 says the responsibilities for nature, the Earth community, rights of nature are grounded in the intrinsic values of nature and all living beings. Touching on the Earth community, community of life, which is also called in the Hague Principles, who is the community of life? Of course, we tend to say that the humans are the center of the world, and we are the integral component of the community of life. But no, the community of life starts with, of course, one of the biggest mammals in the world, which is the whale, the humpback whale, to the littlest or the smallest creatures, which is the bee. And it's kind of significant at this point that Costa Rica has actually, in San Jose, they had a law saying that bees are actually part of, well, citizens of a particular city. So that was a very ecocentric worldview that was expressed in Costa Rica. Now, why Earth trusteeship, which is, of course, the matter that is probably seeking some answer. Why have we chosen Earth trusteeship? This is a picture of the Earth. The Earth has no legal status or definition in international law. When it comes to the Moon Treaty, which was adopted 42 years ago, it applies to the Moon, of course. For example, the Moon can be used for peaceful purposes or activities. And other celestial bodies, which of course are planets, but Article 1 of the Moon Treaty specifically excludes the Earth. So it applies to the Moon, it could apply perhaps to Mars, but it has no application at all to the Earth. So it's bizarre that states have no enforceable obligation to care for the Earth, again, Bosselman. So we can negotiate treaties respecting the climate change or the Earth, but at the end, do states really have a legal obligation to comply if there is a breach of these treaties or environmental agreements? Again, why we go to the tragedy of ecological fragmentation. We have climate change, treaties for climate change, Antarctica, wetlands, Ramsar Convention, biodiversity, the CBD, pollution of oceans, MARPOL. But what about the Earth system? My mother used to say, too many cooks spoil the broth. Why can't we, instead of having a dissected approach to environmental governance, why can't we focus on the Earth system as it is? Now, the Earth system is a complex living system, interactive forces, as we said. Authors have said the Earth comprises of 5 main parts: the chrysosphere, the lithosphere, atmosphere, biosphere, oceans. So we see Earth as a hardware and a software. Hardware mean what we can see with our visual eyes, visually in outer space, but software are the things that are not, we cannot see at the naked eye, with especially, let's say, atmospheric pressures, climate change, which we cannot see, of course, immediately, but we see it over time. So why don't we look at the Earth system as one integrated system? And the Common Home for Humanity has been doing some great work on that particular aspect. Then we have multiple crises. We have a lot of crises going on, biodiversity crisis, climate crisis. 38 governments declared a climate emergency. Now we speak about the elephant in the room, of course, the COVID-19, which, according to scientists, what we have at our disposal at the moment was caused basically by our interaction or exploitation with the natural world and the natural environment and also wildlife. So we now need to think, how do we interact? How do we interact with nature, wildlife, and the natural world? What steps should we take? And of course, we're in the second decade of the UN decade on ecosystems and restoration. How can we use this multiple crisis and our awareness of what is transpiring in the world today to actually push forward on our agenda for the next 8 years we have in this UN decade? How do we reconcile that? So we're in a new epoch, the Anthropocene. 21st of May, 29 scientists out of 34 voted to say that we have entered the Anthropocene since the mid-20th century. They actually had a retroactive perspective on it. And of course, that was with the Industrial Revolution that took place in the 50s or the 60s. So we have moved away, according to scientists, from the relatively stable Holocene period to a new geologic epoch shaped by human activity. And this, of course, raises some alarm bells, raises the red flag. We are probably now what you could basically frame the crises of all crises, that is the ecological crisis. So what is trusteeship in international and domestic law? Of course, let's start with international law. The League of Nations, Sacred Trust of Civilization, Article 22 of the Covenant. Basically, it's the colonizers have, at that time, overseeing the advancement of former colonies. So they call that the Sacred Trust of Civilization, which continued under the UN Trusteeship Council. Kofi Annan and the UN Trusteeship Council, if I may say, is now defunct. It's one of the principal organs of the UN. It's been defunct in 1994. This led Kofi Annan in 1997, the Secretary General at the time. He proposed a new concept of trusteeship for the global commons, including atmosphere, oceans, outer space. And we have recently the new Secretary General Guterres report, who calls for a repurposed trusteeship council. How can Earth trusteeship fill this vision? We have Werman 3J from the International Court of Justice referring to the principle of trusteeship of Earth resources 3 times in the Gabikovo case in 1997, the same year Kofi Annan proposed a new concept of a trusteeship. And of course, he referred to it as the first modern principle of modern environmental law. In South Africa, there was also a domestic law case, the Constitutional Court, the highest court in South Africa, said the present generation holds the earth in trust for the next generation, but this trusteeship position carries with it responsibility to look after the environment. So we see earth trusteeship in different forms or fashion, creeping up even in domestic law, at international law level. And this was before the Hague Principles actually was adopted. Then there's Ben Benitzi, from the professor from University of Cambridge, who, this is a legal theory, trustee for states as trustees for humanity, that is states as trustees for the global welfare. So it's time to see of states as, why can't we see the earth as a common concern, for example, or earth as a common heritage of life, which some academics have been proclaiming, because the earth in the end is for the common welfare of all. And if we see the states as trustees, the states as trustees of humanity, then why can't we see the global picture of earth being a common welfare for all human beings? So I'll just end off with the challenges of earth trusteeship. Of course, we have challenges of political will. For it to be driven as a tool of governance, it has to be accepted by all states, or at least a majority of all states. So the opinion is, how do we get states to actually accept that they are trustees for the earth? Citizens, I think, maybe, of course, global society may be easy, but how do we get states to actually fulfill that? There's a colonial baggage associated with trusteeship, as we saw in international law, especially in the League of Nations. And this led Ben Benitzi, he actually posed this question: can trustees be trusted? So in this case, can states be trusted? In that, can states who some see as responsible for the ecological degradation that we have been viewing, can they have brought us to the ecological crisis? Can states bring us out of it? So that's, of course, goes back again to how much trustees can be trusted. This is, again, political will. Can we agree on a universal declaration focusing on human responsibilities in the Anthropocene? So the Anthropocene sets up a whole new dynamic now. This is not 1948. We are here in 2022. How does the Anthropocene play a role in determining law and governance? And this brings me, of course, to the challenge again. It requires, earth trusteeship requires a transformative approach to law and to planetary governance. So that being said, the world is watching to see how we stand up for the earth. In this particular epoch, the Anthropocene, unstable epoch, how do we stand up to the earth? It shouldn't be the world is watching. I think the future generations are watching us. And this, of course, as the Colombian court said in the Supreme Court said in 2018, it's not only the future generations, but we owe a duty to respect the generations that are unborn. So with that, I would just like to end my presentation. I hope I end on time, and I'm willing and open to answer any questions which may arise. Thank you.
Thanks, Justin. I think we'll hold questions until the end. We have time allocated for that purpose. And yeah, I know if I don't get a chance for Justin to ask questions in that period, I'll probably have to email you a couple. Particularly, I like the point about the colonial baggage. I think that's pretty fascinating stuff. Okay, so let's move to our next speaker now, Jolene Holtz. Jolene is a second-year PhD candidate at the Grotius Center for International Legal Studies at the University of Leiden and based in Amsterdam in the Netherlands. She's writing her PhD on the topic of collective human rights and climate change, reviewing the possible advantages of collective human rights to combat climate change from both a substantive as well as a procedural angle. Previously to joining Leiden University, Jolene worked for several NGOs in Geneva and London on issues related to human rights and climate change. So, Jolene, if you're ready, please begin. As with Justin, I'll give you a reminder at 5 minutes in a minute.
Perfect. Thank you for that introduction. And I also have a PowerPoint prepared, so I'm just going to start one up. I hope it's there, everyone can see it. So thank you for that introduction, and thank you for the invitation to be able to share part of my research here today at this great event. So today I'll be looking specifically on the possible advantages of collective human rights versus an individual human rights approach to climate change. And I will do this also given the time quite conceptually, so I'm not going into all the individual rights, but really draw on the general advantages and disadvantages. So to start off, I'm going to shortly mention how I actually drew out these advantages and disadvantages. They're not exhaustive, but they're based on this idea of climate change is a super wicked problem. And a super wicked problem, for those not familiar, is a term derived from a wicked problem, which was a term invented in the 70s for those problems that are really hard to solve because they involve a myriad of actors. There's so many different approaches to them, and really for my analysis of a human rights approach, this particular criterion means that it's really important when choosing an approach to try and address as many of the underlying issues and causes and find a cross-cutting approach, because if you don't, it will actually cause all of these new wicked problems, which then again are really difficult to solve. And so in the climate context, that means that I've particularly looked at the ways that it can address some of its neo-colonial and imperialist roots. But climate change is not only a wicked problem, as it says on the slide, it's a super wicked problem, and that means that it has 4 additional characteristics. And these are, first of all, that for climate change, time is running out. So it means that we need an approach which can be addressed quite can quickly sort of get results. And the second one is that those responsible are seeking solutions. This specifically plays into the state-centric system and particularly, of course, global North states, so related to common but differentiated responsibilities. The global North states have caused the most emissions, so they are also the ones that have to do the most to combat climate change, which is a big hurdle in effectively addressing it. And the third is for the solution that the international community has given us for climate change with UNFCCC, there's a weak or non-existent central authority. So they do have some compliance mechanism, but it's rather weak. And the last bit, I'm not going into detail, but it's irrational discounting, and shortly put, it's sort of an extension of the cost-benefit analysis. And it really looks at that part of climate change, the difficult temporal scope. So we know that there will be these events in the future, but we're not sure whether they will actually happen. So when deciding on a policy approach, And what usually happens, if they're based on a cost-benefit analysis, they will sort of apply a discount rate on these future costs because they're not sure whether they will happen. So they're actually only taken into account for a little bit. So any approach should also look at how to addressing this temporal scope and, well, not be based on a cost-benefit analysis. So these are the aspects that I looked at. And if we then go to individual rights, there's several advantages that can be observed. First of all, there are relatively well-established monitoring mechanisms at both the regional as well as the international level. Of course, it depends per region, but generally speaking, they are rather well put together. They've been there for a while, and especially contrasting to some other more other approaches, the human rights regime can be quite helpful for that. And then there's also the possibility of human rights actually addressing some of the underlying issues. So being a dissenting voice for short-term economic gain by not applying a cost-benefit analysis, but looking at other issues such as social justice. And then an important one as well, which is contrary, of course, to all the other more state-centric approaches, that is actually well, most commonly, as the presentation would suggest, individuals that are rights holders. So there's actually individuals that have some sort of power to try and address these issues instead of relying on states to sort of step up. So it provides a great avenue for that as well. And then if approaching the human rights regime from, in my view, the most perfect way, it would be that human rights are actually there to correct power imbalances. Of course, it can be critiqued in how effective it is on this particular part, but the fact that this is an important facet of human rights can be quite helpful if we then again look at those roots that I mentioned, which are really firmly grounded in these massive power imbalances. So also possibilities there. And this I already mentioned, but this is again specifically related to refocusing the viewpoint when approaching climate change. So possibly reducing these new wicked problems by trying to take a more cross-cutting approach. That, as it was already on the slide, there's of course also some shortcomings. And when we're specifically considering that most of the human rights system consists of individual rights. And first of all, I think a very well-known critique is that the individual itself is the embodiment of the able-bodied white man, and sometimes even compared to more of a corporate being than anything else, and which we can also see because human rights language has been appropriated by corporations, if we, for example, consider SLAPP lawsuits against public participation. So particularly true for civil and political rights. This is quite a barrier because, again, you are approaching it very one-sided. Then an important one, and I think also this will be a big part of the discussions today, is the risk of the individualization of nature when approaching it from an individual rights perspective. And of course, this is also encapsulated in the term the tragedy of the commons. So the fact that nature is just there to serve particular individuals and has no value on its own. And the fact that then within the human rights approach, there is not, if we're talking about individual rights, not a proper way to actually account for this. And the value of nature itself is a big impediment to actually making sure that, you know, we're not causing more problems by approaching it from a certain way. And then the third one, and this specifically relates to that irrational discounting, as I mentioned, is accounting for future generations. There are some interesting developments within the rights regime on rights of future generations, but this should be incorporated in a good way, have also some intrinsic value to actually account for this temporal scope of climate change. So when taking into account future generations, you're taking into account from a different perspective the costs, if you will, on these generations. Then the human rights regime generally, and that's why I said if you apply that correcting power imbalances correctly, is mostly the individual versus the state, but as we all know, there's more actors and more powerful actors on the stage, which means that there's also a shortcoming there because it cannot address all of the issues, even though some are very pertinent. And the last one is what I call the public interest doctrine. You probably already know this as well, but of course you can, the state can say that they're violating an individual human right because of the public interest, which can reinforce this state-centric system again and complicate that specific part of the human rights approach. So going through the most important part of the presentation, collective human rights. As I mentioned, I'm just going to discuss collective human rights generally, and it has been defined as those human rights generally recognized to be exercisable by collectives and not reducible to the individual. And this is an idea which is quite common, for example, in Africa, where we also have the conventional human and people's rights. And I illustrated here with this picture of Akan culture, which is a crocodile with two heads and one stomach, which sort of symbolizes the personhood there. You can, of course, try and eat everything yourself, but ultimately you're sort of feeding the same stomach. And similarly, this idea of it not, well, it won't be very pleasant to try and divide them. So within the human rights framework, collective human rights have been set to be so-called solidarity rights, which are contrary to the individual rights, which are grounded in individual freedom. And instead, these rights will be grounded in solidarity. And so Karl Vasek coined this term, and he said that it related to those, to a need of concerted efforts by a myriad of actors to tackle some of the issues that will inevitably emerge from the increasing global interdependence. And so this is really reflective of the need to address, so inherently within this term, these different actors. And then secondly, collective human rights have also been said to have a prerequisite status, which means that the realization of collective human rights will be necessary for actually the realization of individual human rights. That somehow, even though human rights are indivisible, that they are still a necessary condition for these individual rights. Then moving to the more conceptual framework. I'm going to put this very shortly so I can understand if there's questions about it. But reading through general theories on collective human rights, which I have to say are mostly from Western scholars, and because this move is away from individual freedom and more like the Kantian division between mind and matter, it actually focuses a lot on the object. So the idea of collective human rights that I have is sort of a merging of the object and the rights holders of collective rights, where the object will be a common good and the rights holders will be a very flexible concept based on a closeness or relatedness to this particular common good. And they have to be a de facto entity, so exist in reality, which also means conversely that duty bearers at the least are de jure entities such as the state, but most notably also corporations. So this is going to be tight in the time frame, but I'll try and rush through it a little bit. If we then compare it to the individual and collective rights, we can see some distinct advantages of collective rights on the right here. One is specifically, it allows for ontological flexibility to counter the individualist idea. As I already mentioned, the individual rights regime is an embodiment of more the Western thought that really is separating mind from matter. And so it also doesn't have this idea of how we relate with our environment and more specifically nature, which is an important second point, is that collective human rights in that way can allow for more holistic understanding of that interrelatedness and account for nature when applying these rights. And the third one is the possibility to incorporate future generations within a community conception. So a lot of these communities have strong roots to the ancestry, but also to future generations. So within that conception, also future generations could be taken into account. If we then apply it to this idea of solidarity rights, as I mentioned, it could also possibly break through this individual versus state dichotomy. Of course, the collective is then also recognized between the individual and the state, if you will. And applying the solidarity rights could then also possibly allow for better understanding of corporations too. And the last one, and this also has a little bit to do with the procedural hypotheses that I have, and I'm happy to expand on in questions later, is a possible shift in balancing with the public interest. So would it be any different choices that are being made if it's the collective versus the public, or individual rights versus the public? And that 1 minute mark leads me to my final slide. So of course, there's also some challenges and difficulties when it comes to collective human rights. And specifically, even though I haven't gone into the individual, to the existing collective rights, there is a strong association with state sovereignty, particularly when speaking about self-determination, which means that the progressive development of this norm has been sort of scarce, because sometimes it's been equated to sort of right to succession. But there are some recent developments actually that are quite hopeful in this way, and I'm particularly aiming for the UN Declaration on the Rights of Small-Scale Farmers and Peasants, that sort of conceptualizing sovereignty in a different way, in that case food sovereignty. And another important point to consider is a possible abuse of representation of the collective. I've not gone into that much, but I find it a very interesting idea to look into what an intersectional approach to representation might look like. So then, rounding everything up, of course, the title of the presentation was complementary or contradictory. I think I've sort of implicitly already mentioned that it's not that contradictory. But it can complement it quite well, and I've generally seen that there's not enough, in my view, disadvantages to not seriously consider the possible advantages collective human rights may have. And I think, for example, the discussions around the right to a healthy environment would be a good start to consider also the application as a collective human right. So I come to the end of my presentation, a little bit over time, I think. But when I first practiced it, it was 30 minutes. So I'm already, I think, a little bit in better shape. So thank you everyone for listening. And I very much look forward to your questions later on. Thank you.
Thank you, Helene. Excellent presentation. Some of that, the tension you mentioned as well, and sort of unpacking, and that tension, I think, is going to be very important moving forward. And I think we're going to have some excellent questions in the discussion section for this panel, for this session, sorry. Thank you again. Our next speaker is actually speaking on behalf of a number of co-authors as well. So Anna Flavia Coletto. Anna is a master's student in socio-environmental law and sustainability at the Catholic University of Paraná. Her research focuses on analyzing the treatment of human mobility in the context of climate change in Latin America. She's currently part of the climate performance of the Brazilian judiciary in the Amazon, Pantanal and Atlantic forest biomes. This project is approved by the National Council for Scientific and Technological Development. Anna, I'll pass over to you.
Thank you, Paul. I'm going to share my screen here. Well, I hope you're seeing my PowerPoint presentation. Good morning, everyone. Today I'm here to talk a little bit about the necessary resumption of the action plan for the prevention and control of deforestation in the legal Amazon as a way to promote climate justice. So I'm going to bring a little bit of the Brazilian perspective to the presentation. So we intend to analyze the action plan and its results, the argument of breach of constitutional precept 760, and how the argument seeks the responsibility of the Brazilian government, federal government, and tries to promote climate justice. So the Amazon is the biggest rainforest of the world. It is present in 9 South American countries, and most of its part is located here in Brazil. So we have about 60% of the Amazon, which makes Brazil one of the mega diverse countries of the world, due to the expressive diversity it holds because of the Amazon. Because of all of this biodiversity, the Amazon is very important for the local, regional, and planetary climate balance. And there is a little difference between the Amazon, the biome, and the legal Amazon. Legal Amazon was a concept adopted by the federal government to implement economic and social development in the region. So the legal Amazon englobes Amazon, the biome, but it also englobes parts of other biomes, such as the Cerrado and Pantanal. Even though the Amazon is very important for climate stability, most of Brazil's emissions come from land change use. For example, in 2020, 46%, so almost half of Brazil's emissions came from land change use. And of course that this is linked to deforestation and forest degradation. In 2021, last year, Carbon Brief carried out a study and placed Brazil as the 4th country that most contributed to world's emissions between 1850 to 2021. So to exemplify, between 2003 and 2004, deforestation levels in the legal Amazon reached about 30,000 square kilometers. 30,000 square kilometers is almost the size of Belgium, which is a country. So almost 20 years ago here in Brazil, we were deforesting the size of a country in one biome, okay? So of course we have a problem. We have a problem that brings a negative repercussion because of its impacts that are related to land use change, and we need to find a solution for this problem. And the solution came through the adoption of the action plan. So in 2004, the federal government of Brazil adopted the action plan for the prevention and control of deforestation in the legal Amazon. Here in Brazil, we call this plan PPCD, okay? And the objective of this plan was to reduce 80% of annual deforestation rates in the legal Amazon by 2020 in relation to the average that was recorded between 1996 and 2005, which was 19,625 square kilometers. So what the plan was trying to do, it was trying to reduce deforestation in 15,700 square kilometers. In other words, we can say that in order to achieve the 80% reduction rate, a deforestation of 3,925 square kilometers per year is allowed. And of course, that after the plan was adopted, the government realized that fighting and managing deforestation was important to reducing GHG emissions. So in 2009, the action plan was co-opted by the National Policy on Climate Change, which is a Brazilian law that aimed to reduce Brazil's emissions between 36 to almost 39% by 2020. This was a voluntary target that was assumed by Brazil during COP15 under the Kyoto Protocol. And of course, that in order to reach that target, Brazil relied mostly on the success of the plan. So here I brought a little bit of the results of this action plan that we're talking about, the PPCD. And the plan was quite satisfactory. It brought very good results. It was divided into 4 phases. It had different objectives, different guidelines for each phase. And here we bring the results that are related to the reduction rates in percentage for each phase. So during the first phase, and here we are considering years 2006 to 2008, we had a reduction of 34% in deforestation rates. Of course, that it was the first phase of the plan. here we're talking about the 80% target. It was the first phase of the plan. So we learned and we improved for the second phase that covered the years from 2009 to 2011, and we got to a 64. But the best results came during the third phase. In the third phase, we reached 72% of the reduction rates in the Amazon. Only in 2012, we reached 77% of reduction. So the most successful phase of the plan was the third one. And when we received these results, we thought we would have even better results in the next phase, because it would be the last phase of implementation of the plan. But this didn't happen. Actually, the contrary happened, and the plan kind of started to decay, because the reduction rates for the last phase that covered years 2016 to 2020 was 56%, so 16% less than the third phase. And why did this happen? So,
sorry, Anna, can you hear me? Sorry to interrupt.
Yes.
We're still on the first title slide. Yeah, so I'm sorry. I think it may not be going into that. There we go. It's moving now. Okay. You might have to move it. You might have to move it. Scroll down and click on the slides. I think if you're trying to hit spacebar, it's not working. So just be mindful of that.
Is it working now?
Yeah, it's moved down to slide 9 now. Yeah.
Okay, thank you. I'm really sorry. Okay.
That's okay.
But here are the results. If you guys would like to see, I guess it's easier. But okay, so we were supposed to have even better results in phase 4, but this didn't happen. And why didn't it happen? So in 2019, we had a new government taken in, and what happened is that the plan was buried by this new federal government. So the plan was legally in action. It was not expressly revoked, but some actions taken by the federal government disrupted the working of the plan. So for example, we had a decrease in the number of inspections carried out by environmental agencies. So we didn't have the punishment of all environmental crimes. We also had the suspension of the Amazon Fund, which was the fund responsible for raising money for the action plan. We also had the annihilation of governance structures of the plan. So the permanent working group and the executive committee of the plan were terminated, and these structures were responsible for executing the plan. So what happened was that the plan was simply paralyzed. It was simply suspended, even though it was supposed to still be going on. And of course that we had an increase in deforestation levels because the plan was not being executed. So here I brought a chart, and then you can see that in 2019 and 2020, deforestation levels rose to almost 11,000 square kilometers. So this basically takes us back to the first years of implementation of the plan. 2021 was even worse. We reached 13,000 square kilometers of deforestation. So we have a growing tendency of deforestation in the legal Amazon, and something has to be done to stop it. So on November 11th of 2020, 7 political parties, along with the help of several Brazilian institutions such as Greenpeace and the Climate Observatory, filed the argument of breach of fundamental precept number 760 in the Brazilian Federal Supreme Court. And what is an argument of breach of fundamental precept? So this is a constitutional action that aims to combat acts that are contrary or that disrespect the so-called fundamental precepts of the Constitution. And these fundamental precepts are the things that the Constitution values the most. So what the argument seeks is to hold the federal government accountable for its actions or inactions regarding the suspension of the plan that led to even higher numbers of deforestation and a higher number of emissions GHG emissions related to land use change. And by holding the federal government accountable, what the argument tries to do is to have the resumption and effective execution of the plan so that Brazil can achieve the climate goals it assumed in front of the international community, and so that deforestation levels don't reach the tipping point, so that Amazon doesn't get to a point that the biodiversity is so threatened that we cannot regress, that we cannot fix anymore. And how is this argument capable of climate justice? Okay, it attempts to promote climate justice by trying to ensure that not only the fundamental right to an ecologically balanced environment, which is present on the Constitution in Article 225, but all the other rights that come with this one, the one to have an ecologically balanced environment. Because if I have this one, I can have other rights such as the right to life, the right to dignity, the right to health, the right to of indigenous and traditional people. So we have here a mixture of human rights, in this case, fundamental rights protected by the Constitution, and we are trying to safeguard the rights of the most vulnerable people. So the argument even says that it's trying to guard a future in the present for people, especially the most vulnerable ones, such as kids, teenagers, who need a stable environment to develop themselves, such as the indigenous peoples. And of course that the resumption of the plan would just make Brazil pay its share on what concerns climate change, because it would be mitigating its historical emissions that come from land use change. So even though the argument is really important and it fights for the resumption of the plan that we need, it has not been judged yet. So we still don't have a plan to protect the Amazon from being deforested, but we need the resumption, the plan now, so that deforestation levels don't continue to rise, and so that we can reduce our GHG emissions that are related to land use change. That's it. Thank you. I'm really sorry about the slides, but thank you so much. If you have any questions, I will be happy to answer them. Thank you.
Oh, thank you, Anna. That's okay. Don't apologize for the problems with the slides. I think we all followed the narrative of your presentation very easily. Thank you. It flowed very, very well. So I think hopefully there'll be questions, but I think there'll be more to do with your analysis and content rather than anything else. Thank you again, Anna. Okay, so moving to our next speaker now. Mariana, are you with us, Mariana? I know, yep, there she is. Just had a couple of issues with maybe the login just earlier, but I think that's resolved now. So Mariana is also going to be speaking on behalf of a group of colleagues regarding her particular topic. So Mariana is a doctoral student in law at the Federal University of Santa Catarina. She has a master in law from the Faculty of Law at the Federal University of Mato Grosso. She's a specialist in civil procedural law from the Escola Superior Foundation of the Public Ministry of Mato Grosso from 2017, and a member of the, I'm not quite sure how to pronounce it, I think it's a Jus Climber research group. And she graduated in law from the Federal University of Mato Grosso in 2015. So, Mariana, I'll pass over to you. And Mariana's topic is a law for the Anthropocene, justice and ecological sensitivity in the case of Lagoa de Conceição, is that correct?
Yes.
Oh, excellent. Okay, thanks, Mariana. Please go ahead when you're ready.
Hello, good morning, everyone. Actually, here in Brazil, it's almost good night because it's around 7 p.m. I had a problem with the sharing, so Sarah is going to help me with that. Thank you so much. Is already sharing the screen. Thank you, Paul, for the introduction. Well, my name is Mariana Coelho. Unfortunately, Professors Morato Leite and Patrick Ayala, co-authors in this work, were unable to attend today, so I will present our work in the name of them and myself. So the title of our work is A Law for the Anthropocene, Justice and Ecological Sensitivity in the Case of Lagoa da Conceição. I will briefly present the idea of the work in 3 parts, in which we will discuss the problems of the Anthropocene, the idea of ecological sensitivity, and finally, a recent case in Brazilian jurisprudence regarding the rights of nature, which demonstrates the emergence of this new environmental paradigm. So going to the first moment, we're going to talk about the Anthropocene. So what is the concept of Anthropocene? The concept of Anthropocene defines a new and current epoch in which human societies have become the main global geological force. So it shows us that human enterprise over the centuries has had remarkable consequences for the Earth system's functioning. So when we talk about an Anthropocene epoch, relating it with environmental laws, we are talking about a major process of human interference on the integrity of the Earth itself. So in this work, we state that the Anthropocene exposed a set of challenges for the protection of nature. The main challenge can be characterized, in short, by the protection of nature in a regulatory reality of business as usual development, in which has already been proved that is not sufficient to prevent irreversible transformations on the Earth. So associated with this insufficiency, a second challenge can also be identified for the distance between law and ecological process. Why? Are we protecting the environment or are we protecting the nature? So the definition of environment is a legal reality I'm sorry, I'm lost. So, okay. The definition of environment is a legal reality in which has already been welcomed by national and international legal orders. So various constitutional orders today define environmental rights. However, the same cannot be said for the definition of nature. And a reason for it can be illustrated through the business as usual paradigm, which it may suggest that if humankind imposes limits on its freedoms, nature can adapt to transformations, assuming that nature has infinite resilience. However, it cannot be said or it cannot be admitted that ecological systems will support human interventions indefinitely. And therefore, there is no state of infinite resilience on the planet on the plane of natural laws. Doing it would mean to admit that the rules of nature could be redefined by regulatory standards. However, the law cannot modify, alter, or ignore nature because the rules of nature simply exist. In this way, we cannot deny the urgent need for transformation and adaptation of environmental legal structures for inadequate access to socio-ecological questions. If it is desired that environmental law should protect nature, the first step to do it would be to ensure that regulatory norms do not ignore the laws of nature. This is really important. The limits, the physical limits of nature must be respected. So we will enter the second part of our presentation, in which we will talk about ecological sensitivity and the emergence of a greening of rights. So first of all, it is important to understand the differences between the existing paradigms and environmental law. Although the traditional paradigm of environmental law has a legal commitment with the protection of interests and values of an anthropocentric way, the proposal of an ecological law needs to establish a different orientation. So the notion of ecological sensitivity is used by Oren Paris to define how the perception of ecological concerns is taken into account by institutions, norms, or policies. So for the purpose of this work, the concept represents the notion that the receptivity to ecological concerns by the norms is susceptible to different levels of sensitivity. We can be gauged by the force of influence that ecological problems exert to a greater or a lesser extent on environmental norms, which can suggest a perception of ecological sensitivity or insensitivity. So in this sense, legal norms of an ecological paradigm need to be susceptible to the consideration of nature and the problems inflicted on ecological systems by humans' behaviors of use and interaction with the environment. So an ecological law must be a sensible law in the face of real environmental problems. But speaking of a sense of ecological sensitivity to the law implies, therefore, a change in the ethical or moral foundations in a more inclusive system of justice. So the anthropocentric notion of justice presents some basic complaints that, for obvious reasons, are directed to questions of human dignity, such as the classic discussion regarding the distribution and allocation of divisible goods or damages, or more recently, the discussion about questions of recognition and representation as proposed by Nancy Fraser, for example. And clearly, none of these discussions reflect concern for the integrity of ecological systems. The resolution of the problem, therefore, would have to start from an essentially ecological theory of justice, defining that the intrinsic protection of nature is an environmental legal and in an environmental legal order is important, presupposes a notion that implies respect, especially in relation to the limits of the Earth systems. So if it is identified that the problem of a law that cannot protect nature itself is a problem of justice, through an ecological justice approach, it is possible to justify a resignification of the theory of environmental law towards an inclusion of nature and its moral community of rights. So, and with that, we go to the third and final part of the exposition, analyzing a case in which we consider as being a legal model for the greening of rights. So as a solution to the problems that the Anthropocene approach can prove to environmental laws, we suggest a proposition of a so-called greening of rights. And what would it be, this greening of rights? Or as well, we call in Brazil, ecologização do direito. We would like to bring a recent case in Brazilian jurisprudence, which demonstrate the existence of what we call for the greening of rights, or of an ecological law, as well as its practical application. So in the city of Florianópolis, state of Santa Catarina, Brazil, there is a municipal legislation in which in its Article 133, it states the recognition of rights to nature. You can move on to the next slide, please. So the single paragraph of the Article 133 expressly states rights of nature. In other words, it states the recognition of nature as a subject of rights. It says, the public power will promote public policies and environmental monitoring instruments so that nature acquires rights ownership. So based on this law and other several legal and scientific grounds, you can move on to the next slide, please. A research group of the Federal University of Santa Catarina called Environmental Law and Political Ecology in the Risk Society, led by Professor Morato Leite, proposed a class action on rights of nature. The class action was proposed in May of 2021, last year, and aims to ensure the recognition of Lagoa da Conceição, that is a lagoon localized in the city of Florianópolis, as a subject of rights in order to guarantee its birthright as a living being to remain healthy. So the development of the initiative started after several discussions about the rupture of the Lagoa da Conceição sewage treatment station in January of 2021, which was a huge social environmental disaster. You can move on to the next slide. So we consider that the class action of Lagoa da Conceição clearly highlights the emergence of a so-called ecological turn of rights, or of a greening of rights. And why we state that? Because in its preliminary decision, the judge recognized the existence of a structural problem of massive violation of environmental and ecological rights in the lagoon, and as a practical measure, determined the foundation of a judicial chamber for the protection of the Lagoa da Conceição to guarantee the ecological integrity of the natural entity through socio-ecological judicial governance. So herein, the preliminary decision performs an intrinsic valuation of nature to weight the interests of humans to exploit and the interests of the environment to be safeguarded, prevailing the protection of the latter, so prevailing the protection of nature in an intrinsic way. So the class action is still running. There is no sentence yet, and it will probably take a long way to finish because of the various actors that are involved. But this preliminary decision already reveals a legal reasoning under significant ecological sensitivity that takes the form of an equal consideration of nature and the responsibility towards the other, in this case, the lagoon, appears as a reflection in an inclusive and differentiated process of justice. So going to the conclusions, by recognizing this, the decision performed a different direction for environmental regulation, one that is better suited to the ecological realities emphasized by the Anthropocene era. More than ever, environmental law must evolve towards the consideration and inclusion of the value of nature in its moral community of rights. This is necessary in order to ensure that regulatory norms do not ignore the laws of nature. And this is how we conclude our presentation. Thank you all for your interest and your attention. And thank you, Sarah, for sharing the slides. Thank you.
Thank you, Mariana. Again, another fascinating presentation, and thank you again for this idea, and to Anna as well, these case studies, which are very, very helpful, I think, to see the implementation of what we are sort of talking about in a fairly highly conceptual level, but in a very sort of distinct and real legal context. Excuse me. So we're going to move to our final speaker now. Sorry, I'm just quickly bringing up something up on my screen. Okay, so Gabrielle is going to present on behalf of, again, a number of colleagues and co-authors. The paper is entitled Environmental Conflicts and Ecological Law in Brazil, Challenges and Issues. Gabrielle Fagundes holds a master's degree in law from the Federal University of Santa Catarina, Brazil. She's also a member of the Environmental Justice Observatory and postgraduate student, a doctorate student at the Law Faculty of the Federal University of Santa Catarina. She's currently doing a 6-month research period at the University of Coimbra in Portugal. Gabrielle, I'll hand over to you.
Good morning. Here in Portugal, it's already around 11 p.m. So good evening too. I would like to thank Professor Paul Govin and all the organizers for having me. So my name is Gabrielle Fagundes, and the colleagues who did the abstract with me are Letícia Buquerque, Isabella Barbieri, and Marcelo Mosman. They are all here as attendees. We are from the Federal University of Santa Catarina in Brazil. How said by Professor Paul Govin, I am a PhD student. Letícia is a law professor Marcelo and Isabelle are lawyers and researchers. I don't have a slideshow. It will be just me talking. I'm going to talk about environmental conflicts and ecological law in Brazil, challenges and issues. This research on environmental conflicts and ecological law in Brazil is linked to the Ecological Justice Clinic, which is a project to encourage the practice of law at the law school. The clinic begins in 2018 and has 5 sub-areas of action: democratic participation, health and pesticides, biodiversity and specially protected spaces, animal rights and climate litigation. And through the research conducted, the main cases are chosen for the work of the clinic. In this way, the PhD students work together with undergraduate students to find solutions and support NGOs in defense of human rights and the environment. Brazil is a large country with different regions, different realities. Therefore, I will start with the following question. What is the situation of environmental injustice in Brazil, and how social movements, traditional communities, and indigenous peoples fight against the suppression and violation of rights? The main objective is to reflect on the contradiction of the current new extractivist policy in Latin America and the lack of compliance with international laws, as well as the scenario of social environmental regression in Brazil. The situation makes it possible to examine the evolution and contradictions in the construction of the human rights system, especially with regard to indigenous peoples and global justice issues. The right to an ecological balanced environment is considered a fundamental right in the Brazilian Constitution. The Constitution introduces, in addition to an economic dimension, an adequate commitment to life, both for present and future generations, and a systemic view of the environment. That is, the environment is perceived as something essential for all forms of life and not just as an economic resource for human beings. However, the process of redemocratization and constitutionalization of the environment did not change the development model adopted by the military during the dictatorial period, much less reduce the scenario of social and environmental injustice. On the contrary, the number of social environmental conflicts is increasing. Land disputes caused by the expansion of the mining, cattle raising, and other commodity production, conflicts over the use and appropriation of natural resources, and issues involving the demarcation of indigenous lands and quilombola territories are constant. The Brazilian development model continues to be guided by a logic of exclusion and predation without considering minimum parameters of respect for human rights and the environment, especially in relation to vulnerable communities that are outside the dominant system. The Ecological Justice Clinic acts in the defense of these vulnerable groups. Well, first, we have many problems concerning biodiversity and especially protected spaces, issues linked with the destruction of animal habitat. Pollution and deforestation cause a lot of damage to the life of animals. The expansion of agriculture and mega projects such as the construction of hydroelectric dams, are the center of this issue. It's important to mention that 1 million species are going extinct all over the world due to habitat loss and global warming, and that number keeps growing. We can see that due to global warming, we are experiencing the 6th mass extinction on Earth. In addition to a huge socio-ecological damage to traditional communities of fishermen, collectors, and other segments adapted to an intrinsic relationship with nature. This is why the protection of ecosystems, their biodiversity and resilience, especially in protected areas, has gained a relevant space in the Ecological Justice Clinic acting, as will be referred to later in this presentation. Second, we have several discussions about health and pesticides. Now, Brazil is one of the biggest consumers of pesticides in the world, a situation that is worsened by the regression scenario. In the period from 2019 to 2021 alone, 1,550 new pesticides have been approved. In addition, Brazil is the largest consumer of banned pesticides, with those that were banned in the EU now being exported to our country. Third, we have the issue regarding animal rights in the same regressive situation. With alternative bills to Congress presenting less protection and the creation of bills to approve the hunting of wild animals and the export of live cattle. Finally, we have the situation of climate litigation. And before talking about climate litigation, it's important to talk about the concept of climate justice. Well, climate justice is a term used to frame global warming as an ethical and political issue, rather than one that is purely environmental or physical in nature. This is done by relating the effects of climate change to concepts of justice, particularly environmental justice and social justice. And within the context, climate change litigation is an umbrella term encompassing disputes that relate to climate change, as well as litigation to catalyze legal, policy, and social change on the issue of climate change. The argument of human rights violations due to the effects of climate change has also been used in climate litigation cases in several countries, mainly linked to the duty of states to protect their citizens. In Brazil, while climate litigation against private actors have been gaining more attention and employing creative legal strategies, litigation against the government is also keeping pace, as illustrated by a recent case filed against the Brazilian federal government and the Ministry of Environment. On October 26, 2021, just a week before the Glasgow Climate Change Conference, 70 NGOs led by Observatório do Clima filed a public civil action claiming that the current Brazilian national policy on climate change, set forth by law number 12,187 from 2009, is inadequate and unable to provide a response to the current climate crisis. As such, the plaintiffs require that the policy be updated with new commitments effectively fit to contribute in the fight against climate change. Overall, however, Brazil has modern avant-garde environmental legislation. The problem is its implementation. Activists played an important part in the enforcement of the legislation. Environmental activists in Brazil has initiated important cases in the Supreme Court concerning changes in legislation and the problems with implementation. In November 2018, for instance, the Ecological Justice Clinic prepared an amicus curiae request on behalf of civil society organizations in direct action of unconstitutionality 5385, which deals with the recategorization of the Serra do Tabuleiro State Park, which is the largest fully protected conservation unit in the state of Santa Catarina. It was created in the 70s with the goal of protecting the rich biodiversity of the region and the water sources that supply the city of Florianopolis and the south of the state. However, in 2009, the state of Santa Catarina passed a law redefining the park's boundaries, and around 7,600 hectares were turned on environmental protection area. A modality more lenient of protection compared to permanent preservation areas, as admits human occupation and allows the exploration of certain activities. After that, there were already reports of irregular subdivisions, mining activities, rice farming, and the installation of an industrial zone. Thus, in 2015, the Attorney General at the time proposed a direct action of unconstitutionality, questioned the recategorization of the park. The action presented to the Supreme Court challenges some articles of the law from 2009, which reassessed and defined the limits of the park, resulting in a mosaic of conservation units. The suit highlights that the shredding of the integral preservation unit for the creation of environmental protection areas, besides violating the federal constitution, did not respect the law of the national system of nature conservation units, which requires prior public consultation. The direct action of unconstitutionality has been followed by the clinic since 2018 by my colleagues Isabelle Barbieri and Marcelo Mosman, who are accompanying the NGOs that make the defense of the park in the action through the instrument of amicus curiae. Well, that was what I wanted to talk about our abstract. Thank you very much for the opportunity to be presenting at this event and for everyone's attention. Thank you.
Thank you. Thank you, Gabrielle. Again, another really excellent presentation, which takes, I think, some of these very difficult conceptual ideas and reconceptualization, indeed, of nature, as is the topic of this session, and looks at how this can be implemented, if at all, within the parameters of legal instruments. And I think that application is very fascinating. It's not easy, it's very challenging to find where this conceptual discussion can take root in terms of practical legal analysis. Okay, thank you to all the speakers. We've already had a tremendously fascinating session, and as I forecast earlier, this has been such an important, I think, way to start the colloquium, looking at this nebulous issue of rights, taking something, a legal idea, which has historically been applied and implemented to the benefit of humanity, and asking where can this be then reconceptualized and applied to the interests of nature. So we have got time now for questions, and we've already got quite a number of questions in the Q&A section, which I'll go through in a moment. So I'll ask anyone who hasn't already contributed a question into that Q&A box to please do so whilst we're moving through the rest of our discussion in this morning session. So I'm going to run through the questions as they've been posted in chronological order. So yeah, I'll just go through one by one and ask the relevant panelists to answer the question as best they can. Okay, so the first question comes from Fern. Hopefully everyone who lodged questions is still with us. Now, I think our panelists can see the questions as well. So hopefully they've had an opportunity to just have a peep and perhaps get some thoughts together. So the first question from Fern is for Justin Sobion. The question is, through the Paris Agreement on climate change, states have committed to conditional and unconditional nationally determined contributions, NDCs, mainly toward climate mitigation and adaptation. The question then for Justin is there an opportunity to streamline Earth trusteeship through this NDC vehicle and commitments? Justin, please go ahead when you're ready.
Yeah, definitely, and I would just like to thank Fern for that question. But definitely, it is. We would welcome that in terms of scholars or academics for Earth trusteeship to streamline NDCs, streamline Earth trusteeship in the NDCs. The thing about Earth trusteeship, it's as the definition we have is the institutionalization of duties. So we are looking at not only the duties at the state level, but we would also welcome the institutionalization of that duty to the Earth, starting from citizens, education in schools, then the state level, and then global. So there are actually 3 levels of the of institutionalizing this duty of Earth trusteeship. So we would, of course, as a practitioner or academic in this particular area, would welcome the NDCs, because the whole thing with Earth trusteeship is not an isolated event. It requires the cooperation of everyone under the HAGUE Principles. It actually says that states, together with citizens, are trustees for the Earth. So that is how I would answer that. Yes, we would welcome that. And mind you, as I said, the Paris Agreement does mention the importance of maintaining the integrity of the ecological systems. The only thing missing there is the Earth, but of course it was intended to be the Earth. So we already see that there are small baby steps already taking place in the Paris Agreement. So that would be my answer to it. Thank you.
Thanks, Justin. Do any of our other panelists have anything to add to that question, or to respond to that question?
I had actually a question, so I didn't put it in the Q&A, but I did have a question for Justin. I don't know if it's a bit sneaky to sort of now put it in between. I don't know if I may.
No, please go ahead. Go ahead.
Okay. I mean, it's been also to Elizabeth as well, because I was also curious about this relationship with like a very global approach to the local level. It's been asked a little bit, but I was wondering, within certain cultures, there's already this idea of responsibilities, even responsibilities before rights. And if you choose a more universal concept, how you actually account for more of these cultural sensitivities to sort of avoid this pitfall that you have with any universal rule, is that it's not that easily applicable to each context. And then secondly, it might be a bit different, but what's the relationship with the trusteeship? Like, for example, I know that Weston and Bollier had like a book on the law of the commons, in which they also conceptualized like the human rights idea related to some global commons, I think, as well. So for example, the atmosphere, and I saw your presentation on all these spheres of the earth as well. So I thought that maybe that's something that feeds into this idea of trusteeship as well. And I'd be curious to find out in what way. So it's actually sort of two questions, sorry.
No worries. Well, just to answer that, well, I'll try to get the second question first. There's, of course, as we know, the global commons and trusteeship of the commons, which is the ocean, atmosphere, outer space, things that, of course, as we know, that they're common to everyone. But trusteeship goes a little bit, earth trusteeship, that is, goes a bit further than that, because it kind of takes everything in a holistic level. So instead of saying, let's have trusteeship for the atmosphere, atmospheric trust is, of course, a big academic, that is a thesis in itself. What is the function of an academic, of an atmospheric trust? But we are trying to say, let's look at the broader picture, which is the physical and the hardware and the software of the earth. So how we can have that under one form of global governance, instead of an atmospheric trust or a trust for the oceans, for example. And you're right with the cultural, earth trusteeship means a lot to indigenous cultures. I would think they are the ones who actually resonate with it more. So for instance, in New Zealand, there's this, of course, the Maori, the indigenous persons, they have a concept called katiaki tanga, which means guardianship. And they see that we are here as guardians of, let's say, for example, the river. There's a river in New Zealand called the Whanganui River, which I recognize as a legal person. And the Maori, the local Maori, they see themselves as the guardians of that particular river. And that Maori terminology has actually been implemented into the legislation of New Zealand. So we see now that there's a partnership. New Zealand is probably one of the first countries in the world to have this partnership between the Crown, well, the Crown meaning because the Crown government, that is, because of course New Zealand is, they still have the head of state as the Queen of England, and we see the partnership with the indigenous persons. And it's just one example where we can see that sort of partnership in legislation. And so that's why I think it's very, it's driven, of course, by indigenous persons. So that's why they can relate to the concept of earth trusteeship. I hope that answers your question to some extent. Thank you.
You're still muted, sorry.
Thanks, Justin. Thanks for the question as well, Pauline. Moving through to the next question in the Q&A box. The next question is for you, Helene, from Nikki Van Dyke. The question is, in your opinion, what might an intersectional approach to representation look like? And a follow-up question, do you have any literature recommendations?
I mean, it is a challenging question, of course, to address, because I put, I think, a question mark at the end of my slide as well. It's something that I'm looking into. And so what I feel is a pitfall, for example, if considering collective rights, and which I do in part as well, strengthening land tenure rights, there have been cases in which particularly women's land rights are then suppressed by actually, well, scaling up in a certain sense. It's this idea of rights. And that was really the part that got me thinking, okay, there needs to be, you have to have some safeguards. So the way that I see it now, and I won't have very good literature recommendations as of yet, because I'm still looking into it, but it's really, if it's a community that identifies as gender, a man, women, that could be an important parameter, so that you have representatives of both, and same goes for age, ability, disability. So really also in maybe related a little bit as the different human rights treaties that we know, which of course is in line with more of this intersectional approach. So that's my general idea, but as I said, I mean, I'd be interested to know as well, still at this point, what exactly it will look like. But these are some of the things that I'm considering, also considering some of the things that sort of went wrong in the past.
Okay, thanks, Nikki, for the question. Thanks, Pauline, for that. Yeah, I think excellent answer. I think it's again, as we got from your presentation, something which is still unfolding, something which we'll all, I think, be learning as we move forward, but definitely one to sort of, I think, watch in terms of its importance. So then moving to the next question, and the next question is for both Justin and Pauline. It comes from C or Shri, sorry, Watini from the University of Islam Indonesia. So the first question is, I think, directed to Justin, and it's related to the concept of trusteeship, again, in the context of climate change impacts, but particularly those climate change impacts which cause severe impact to indigenous people. And the example listed here is the Inuit people of Alaska, North America. Inuit people will lose their place to live in the future because of rising sea levels. The question then is, what kinds of solutions to address this matter from the perspective of human rights and international environmental law? And the second question is, would you also be able to relate this to the principle of intergenerational equity? So just to repeat the question then, what kind of solutions exist in international environmental law and human rights law for I think the how the concept of trusteeship applies to indigenous people such as the Inuit? Justin, can we pass over to you first?
Sure. Thank you again, Paul. I'll be very brief.
Oh no, please take your time.
I'm just actually seeing.
Don't feel you need to be brief.
Yeah, I'm just actually seeing a message there by one of the organizers. But anyway, I think that that's a very interesting question for small island developing states, as we know. Well, the issue of climate change and sea level rises. Even if Earth trusteeship is implemented tomorrow, because it's urgent, but even if it was implemented today, let's say, it's not going to solve, of course, the issue of rising sea levels. But I do think there are future aspects of this question, which is very critical, in that, for instance, I am advising certain Caribbean countries, especially, to join into Vanuatu's, which is a Pacific Island state in the Pacific Island state that is actually bringing climate change question to the International Court of Justice. Well, they are moving in that direction. So I would advise countries to get on board with this particular issue, because it's important for us to have, even though advisory opinion from the ICJ is not binding, but it is important for the ICJ to decide on issues pertaining to climate change, because it would have effects on how we negotiate treaties in the future. It would be I like to call it a norm. It would settle environmental norms in terms of customary international law and how the developed states to deal with the aspects of rising sea levels in smaller island developing states. So I think it sets a trickle-down effect, and it would help us set that customary international law as what are the state's responsibilities, especially for loss and finance. I mean, it goes back to other things, loss and finance, for example. So I would advise look into the Vanuatu issue. Pressure, we have different government groups, well, NGO groups in the Caribbean and the Pacific. Pressure your state to actually assist and to support Vanuatu's climate change campaign. So that would be my advice in a nutshell. Thank you.
Elaine, you want to go ahead and
yeah, I
Yep.
think I can maybe complement it from the human rights part of the question that's being asked. And of course, I think if someone speaks about collective human rights and climate change, this might be the question that's on most people's minds, how to deal with this particular issue related to small island states, but also indigenous communities, which already have to engage in some sort of planned relocation. So how I see it related to the idea of collective rights that I have in mind is, well, it's heavily, of course, tied to the right to self-determination, and really this idea that people should be able to sort of control their own destiny. And once that sort of gets out of hand, that's really when that right is being violated. And also if collective human rights then are construed as a right that really transcends the state boundaries, so it involves these actors, and within the human rights regime plays into the various power imbalances that you have. I can also see particularly collective human rights having the effect that actually maybe such cases can be brought on a more broader scale, so towards various countries and not within this individual state dichotomy, as I've mentioned. So of course, this will be interesting to see. I think maybe a means of subsistence specifically within self-determination can actually be sort of a minimum as well there. That could maybe, you know, if you touch upon that very bare minimum, that's the moment where really the that dichotomy that I was talking about should be let go of, and there should be more legal possibilities in really bringing a claim more towards global north countries, for example. So I know that within the human rights regime, this is a big discussion as well, and there's some people that focus specifically on this, but there's definitely there's some merit there. The question, of course, will be if that's going to happen to be in time and more, most effectively, but that's why it's so interesting as well to hear, for example, a very different approach that Justin is talking about. So hopefully if we combine all of these efforts, something will be possible.
Gosh, on mute again. Sorry. Thanks, Helene and Justin, for your responses to Shree's question. Now, given the nature of the question and the focus particularly on Indigenous people, First Nations people, I'd like to ask any of our other panelists, Anna, Mariana, Gabrielle, if you'd like to contribute a response to this question. So I feel I think when the question was posted, I think it was immediately following the first two presentations. So would anyone else, any of our other panelists, like to contribute a response to this question? No, Anna or Gabrielle? No, okay. We'll move on to the next question then. The next one comes from, oops, sorry, just scroll up on my place. Well, it's another one from Shree. And this one is directed to Anna, so I hope she's still with us. The question is, well, more of a sort of a request, I suppose, from Shree. He asks, I would like to know, the adaptation plan and program that is already running in Brazil. What kinds of programs and strategies have been conducted in Brazil? And also, is there community-based management in terms of sustainable forestry management? So maybe you want to break that question down a bit, Anna, in order to respond.
Okay, thank you, Paul. So under the National Policy on Climate Change, on what concerns deforestation, we have two plans. The one that I spoke about, which is the action plan for the prevention and control of deforestation in the legal Amazon, which is called PPCD, and it is specifically for the Amazon. But as I said, the plan is currently suspended, paralyzed, and we are trying to bring it back with the help of the judiciary power. Another plan that we have under the National Policy on Climate Change is PP Cerrado, which is basically the same thing as the one that we have for the Amazon, but this one is for the Cerrado biome. The objective of this plan is to reduce 40% of the deforestation in the biome, but the plan is also paralyzed and suspended. So we are also trying to bring it back, both plans, with the help of the judiciary power. But we have a new plan that was adopted by the new federal government called the National Plan for the Control of Illegal Deforestation and the Recovery of Native Vegetation. So this plan is an attempt to substitute the two plans that were paralyzed and suspended. What I can say about this plan is it is supposed to work from 2020 to 2023, but the operating plan was released on March of 2021, so it was already late. And as for the implementation of this plan, I can say that deforestation levels continue to go up. In January, last month, the first 3 weeks of January, we already had new records of deforestation in the Amazon, and the year is just beginning. So I don't know what we're doing with this plan. So we're trying to take the old ones back because they had better results than the one that we have now. And for the second part of the question concerning the community-based management, well, we have indigenous people here in Brazil, we have the traditional people, and they have been living and exploring the forest as a way of exploring their livelihood for years without interfering in the forest. So they hunt, they fish, they extract whatever they need as a source of food and income in a way that the balance is maintained. So they have a holistic view of the nature, and their livelihood aligned with the way of life and the traditional knowledge. So that contributes to the conservation of the biomes or the forests, and of course to the maintenance of the ecosystem services. So basically the traditional people and the indigenous people, they take whatever they need from the forest, but that allows the forest to recover itself. So I guess that's it. I hope I've answered your questions. Thank you so much.
Thank you, Anna. Yeah, I think that has answered the question in a very, very helpful fashion. Thank you. Now, moving forward then, the next question is about the Lago de Conceição case. Now, this question, I think, is going to be most relevant for Mariana. There's also a couple of follow-up questions as well, which I think we can probably open up to all three of the presenters from Brazil, but we'll start with this one here. So it's a very brief question from Julia Torres. What is the current status of the court case, Mariana? Can you just quickly take us, well, not quickly, but can you take us through that, please?
Yes, okay. Well, hi, Julia. Thank you for the question. I think that this moment is important because we can explore a little bit more the facts of the presentation that we cannot explore in 15 minutes. So thank you for the question. So after the preliminary decision had been granted, the process is still awaiting the manifestation of the parties, such as the companies involved like CASAM, which is the company responsible for the sewage treatment station, among other actors, in order to determine the creation of the judicial chamber for the protection of Lagoa da Conceição, because it was a judicial determination, such as the composition, the functions, and the objectives. All these things like composition, etc., they have to be created among all the parties. That was a judicial determination. So as the class action encompasses a structural litigation, it is necessary that all parties in the process also participate. So that it is, the process is still awaiting to comply with the court decision.
Thank you, Mariana. Now there's another question here from Shri, which is similar, I mean, based on, I think, the case and some of those issues as well. So the question is, can you please elaborate further as to how the government is going to guarantee and protect the interest of nature and create environmental justice besides recognizing the right of nature in the act? There's another question about class action as well, but if you want to elaborate on that, and the effectiveness of class action in terms of environmental justice. So I think the first bit there, Mariana, yeah, is about how can you, or how can the government guarantee and protect the interests of nature besides the recognition, sorry, of the right to nature in legislation?
Okay, I think that question was made by Sri. Okay, hi Sri, thank you for the question. It's an excellent question. I believe that the government could enable the protection of interests of nature in several ways. With regard to this specific legislation that we talked about, brought in the case of Lagoa da Conceição, this was handled by the plaintiffs requesting the recognition of a subject of rights to the lagoon in order to force a better protection of that ecosystem. So with regard to public participation, several NGOs, civil associations were also invited to participate in the action, some as authors included, and also to participate in the Judicial Chamber of Protection of Lagoa da Conceição. I believe that the effective mechanism to create environmental justice, that was the other question that she made, is one that considers the intrinsic value, the intrinsic protection of nature that is different from that offered by an anthropocentric environmental law. So this legislation, in the case that was exposed, in my opinion, is a mechanism to create environmental justice.
Thanks, Mariana. Now, there's another question coming up, which is also about rights of nature, I think, in the Brazilian context. But I'd also like to just open up that first question from Shri to our other panelists, particularly Anna and Gabrielle. I just want to reiterate the question. It was the first part of Shri's question. How the government, the Brazilian government that is, can guarantee and protect the interests of nature and create environmental justice besides recognizing the right to nature in the act. So what are some other means by which government can protect the interest of nature? Gabrielle and Anna, do you have any thoughts on that one?
So I'm trying to find the question first to be more, to have a context. Where is the question? Is one of the...
If you look in the Q&A box, I don't know, I
Yeah.
assume you can see that. Yeah, if you open that box up, and I think it should be the third question that was from Shri, which was posted at 10:07. Well, 10:07 a.m. my time. I'm not sure what sorry, I'm not sure what time that was on your end. Yeah.
So I will answer this question linking to the question from Julia Torres that is related. What are like the disadvantages of not having a national constitutional recognition of the rights of nature?
Yeah, that'd be good. Thanks.
The Constitution does not recognize right of nature, but it does recognize the fundamental right to the environment, which is already very important for pressuring the government to preserve biodiversity. I don't think it's a disadvantage not to recognize rights of nature. The fundamental right to the environment already allows for comprehensive protection and also makes both the government and citizens responsible for respecting the environment. It's not a question of an absence of laws, but of political commitment and interest in implementation. So.
Thanks, Gabrielle. We'll move to that question now from Julia Torres, another one from Julia. And yeah, I mean, Gabrielle already answered this partly in her response, but I'll just reiterate it for everyone. The question is, what are the disadvantages of not having a national constitutional recognition of the rights of nature, which I guess you could flip and say, what are the advantages of having one? So again, I'll ask Mariana to answer, and also Anna, if you have something to contribute there as well. And then I remember, Justin, if you have any thoughts on that as well, because you mentioned South Africa, which is, I'm not quite sure if Julia had South Africa or another jurisdiction in mind, but I think that could be an interesting perspective also. So Mariana, could we go to you first, please?
Of course. Thank you, Julia, for the question. I will complement after Gabriele, because I think it's an interesting question, because I believe that at least in the case of Brazil, even though we do not have an express constitutional recognition of rights of nature, we have other ways to do it, like infraconstitutional legislation, or even some judicial decisions like the Supreme Courts of Brazil are already advancing in this more ecological sense for an environmental law, as we explained in the paper. So with this, I think that the express recognition of rights of nature in the constitutional text is not that essential. It's not like a great problem, because we are already advanced in this state, at least here in Brazil and in other Latin American countries. I think we are more advanced in this question. So I don't think it's a disadvantage not having a national or a constitutional recognition of rights of nature.
Thanks, Mariana. Gabrielle, or do you have anything else to add? Or Anna, do you have anything to contribute, sorry, to that response?
I believe that if we had the rights of the nature protected by the Constitution, it would be easier for us to plead any other rights that are related to this, because if it's protected by the Constitution, it means, at least here in Brazil, it means that it's something that everybody should have access to, or is something that everyone should care about. So it's not in disadvantage not to have it, but it would be better if we had it. I believe that's my opinion.
Yeah.
Thank you.
Thanks, Anna. Justin, do you mind contributing something from?
Yeah. I also agree with Anna to that extent, especially myself coming from a Commonwealth jurisdiction where the Constitution is supreme. I think if you have in your Constitution a constitutional right for a healthy and enjoyable environment, I don't think I've seen anything as a right to, unless in Belize, the Mother Earth has their own intrinsic rights. So let's say, for example, in South Africa, which does recognize a right to a healthy environment, possibly that particular ruling that I mentioned from the Constitutional Court, it would not have taken that particular turn, because South Africa has that right to a healthy environment. I believe it's under Section 24 of their Constitution. So the court actually said that this trusteeship duty to the earth, and it even went so far, not even to say the environment, but to the earth, it comes with a responsibility which the court has to exercise. So I think they actually triggered that particular pathway based on their reading of the Constitution. So for that reason, I think, especially if your Constitution is a foundational document, in our case, it's our supreme law, it must start there. That's just my take on it. Thank you.
Yeah, thanks, Justin. That's an excellent explanation, I think, particularly from the Commonwealth context. We have I think we have time for one more substantial question. But before we get to that, Mariana, there's a question here from Adam Beeson, who asks, is the judgment for Lagoa de Conceição, is it publicly available, and is there an English translation? I think that's a bit of a yes or no question, I suppose.
Hi, Adam. I don't think there is a English translation of the process or of the preliminary decision, but I think you gave me a good idea. I think we should translate that and share with our research and what is happening here in Brazil. But yes, the process is public, like any process that is not under judicial secret, which is not the case of this class action. Thank you.
Thanks, Mariana. We'll now go to the final substantive question here, and this is directed to Gabrielle. Again from Shri. Thank you, Shri, for these excellent questions. These have been really fantastic and I think thought-provoking for the panelists and the audience. So the question is to Gabrielle. Gabrielle mentioned that Brazil has a problem of legal implementation in terms of creating ecological justice in Brazil. The question then, what kinds of solutions has the government taken to protect biodiversity as part of maintaining ecological justice? What kinds of roles can then be conducted by university students to influence government policy, which has been recognized in the Constitution and participation within the government programs? Gabrielle, if you can answer that one from Shri, please.
Yeah, thank you so much, Dr. Shri, for the question. An ecological justice has the right of participation as a central issue. One important measure is to assure the duty to respect civil society autonomy, self-determination, and participation on environmental issues. The role that can be played by university students to influence government policy is to use legislation to put pressure on the government. The possibility of the clinic training students in the practice of environmental law is also very interesting. After all, traditionally the legal practice in universities is linked to civil, criminal, and family law, not necessarily in environmental law. So that's my answer.
Thank you, Gabrielle. And with that, we reach the conclusion of our first session of the Eighth Frontiers Colloquium into Environmental Law. I'd like to thank everyone who's tuned in and attended this opening session. I'd like to thank the panelists for some excellent, I think, papers which have looked at, again, as I mentioned earlier, not just the concept, I think, of rights and what it means in terms of nature and environment, but also looking at some of the difficulties in application and implementation. And one that really resonates with me is an issue a number of the panelists mentioned, and that's the distinction between environment as a legal definition and a legal construct, and nature as perhaps something broader and something which is more fundamental to human survival on the planet, particularly in the Anthropocene epoch. I'd like to thank again Dr. Joan Ray for the wonderful welcome to country, and just to remind everyone that Jo will be our keynote speaker in our panel this evening, Sydney, Australia time. Coming up today, our second session is going to be at 11:30 a.m. Again, Australian Eastern Daylight Savings Time. And it's entitled Global Law and the Challenges of the Anthropocene, and is chaired by Ethan Berringen, who is also part of the Macquarie University Law School. So with that, I'd like to draw the first session to a close. Thank you again to everyone who has presented, everyone else who's attending, and we hope that you will stay with us in the next few days through the rest of our colloquium. Thank you, everyone, and bye for now.